Okay, hello and welcome everybody to IPC. It's very nice to see our friends and colleagues here today with us. Today we have an event on what I believe to be a very, very pertinent, relevant and topical subject. That is authoritarianism through law, global patterns of legalism's governance. As I'm sure all of you are following developments, not just in Turkey, but also globally, where democratic backsliding goes hand in hand with legal means. And there are cases where law is being instrumentalized across Europe and also in the United States in ways in which it boosts democratic backsliding and also fuels authoritarianism at home and abroad. So today, this event will be basically on this global phenomena through a discussion of the Hungarian case, the Turkish case, and also other cases where relevant. And it is based on a IPC working paper report that's been published by our IPC senior fellow, Professor Alper, Kaliber. And his paper is also called Political Engineering Through Law, Hungary and Beyond. So those of you who are interested, it's also available on our website, and we also attached it to the call for this today's event. So you can also see it attached to your email if you've received the invitation, and also in the online news about the event. So I do suggest that you have a look at it in case you didn't have a chance to do so. So today, IPM will be presenting this research for us, and then we're very, very lucky to have Professor Ayşe Kadıoğlu, our very own Sabancı Professor Ayşe Kadıoğlu, who will be discussing Alper's work. And this also, I believe, fits very neatly with Ayşe Hoca's work on this subject, because she also has been thinking a lot in the recent years about autocratization, global autocratization, and how it connects to the legal context and how law is used to justify autocracies. So we're very much happy that she's with us to share her insights and her views on this. And afterwards, we're going to have two other presenters who will be joining us, who are in fact right now joining us online. Professor Ece Göztepe from Bilkent University, who will be talking about chaos and uncertainty as a strategy of authoritarianism, since I believe this is also super topical, as we are probably going through one of those times where international uncertainty has been at its peak. And I don't know, when was the last time that the international order has been so uncertain. And then finally, we're going to be moving on to the presentation by Attila Antal from Eötvös Loránd University, where he's going to focus more on the Hungarian case. Since the Hungarian case has many parallels with the Turkish case, but also other cases globally. And since also we are very close to the elections in Hungary, which in fact I'm very curious to know where the situation is with those elections as we are fast approaching it. And it would also be great, perhaps we could also have the chance to discuss that a little bit in the time that remains with him and this crowd. So without further ado, I'm going to give the floor to Alper Hoca. I'd like to thank you once again for joining us today. Alper Hoca.
Thank you very much, Selam Hocam. As you also sort of recognize this opportunity to me to discuss this paper, I won't just go into details of course, all the paper, and that's why I strongly advise you to read it if it's interested for you. But I try to present a more general picture, and but I can say that there are mainly two assumptions in the paper. First of all, as Selam Hoca has also mentioned, today's autocracies are built upon law or through law. They are not built upon against law, right? So current autocracies reshape even create their own legal institutions, constitutional frameworks, and legislative procedures, right? And secondly, these are often, as I coined this term, modular emergency regimes, right? They are modular in the sense that they use simultaneously and interchangeably both exceptional emergency powers and also ordinary legislative rules and laws, right? They are also not temporary. They are not temporary responses to crisis situations. Rather, they become permanent frameworks, right? And they are not only observable in fledgling, in weak democracies or autocracies, but they are also in the established democracies. Remember, when Trump has come to power second time, he has signed nearly 100 executive orders. He rules the country mainly through executive orders, right? As we experience this situation in Turkey today, Turkey is not, of course, there are still laws enacted and amended, but here in this presidential regime, we are mainly ruled by presidential decrees, right, which are normally identified, associated with emergency situations. Okay, turning to Hungary. It is, to my opinion, again, a modular emergency autocracy, right? Okay, but at the beginning, it was a success story, right? When the Cold War has ended, when there is a new kind of democratizing waves in the Eastern and Central Europe, right? Hungary was the main democratic success story because it had powerful constitutional court, almost institutions, relatively pluralistic media environment, and commitments to liberal constitutionalism. But this story suddenly began to change in 2010, and it was understood that this democratic movement was a fragile one. By the way, sorry for my voice; it's not in the best shape. Yeah, okay. Fidesz, after came to power, like all legal autocratic party machineries, they began a relentless legal and constitutional activism. Right. First of all, they had super majority due to electoral system, although they got just half of the votes, but together with the other ultra-right party, they had the 2/3 of the majority of the parliament. This means that they enshrined a new constitution. They restructured constitutional court. They changed all the appointment rules for judges, especially for senior judges. The powers of the constitutional court was curtailed. Local governments assets were nationalized. The story is the same. And of course, they began to build a new government-friendly media ecosystem, right? So in 2011, they adopted a new constitution, fundamental law, without any public discussion, right? And then they adopted more than 30 cardinal laws. These are very important laws. You cannot amend, you can only amend them through super majority, two-thirds parliamentary majority, and they affect everything. And they constrain also possible future governments. So these fundamental, through these cardinal laws, they gerrymandered electoral districts. They provided long-term controls over media. They taxed all the crucial institutions with Fidesz loyalists. And again, they constrained constitutional courts, many roles and responsibilities. So it was a kind of legal entrenchment and even legal engineering for the entrenchment of the government. And it also paved the way for constitutional activism. The fundamental law that the Orban government has written or enacted was amended at least 15 times so far. And in these amendments, too many articles were changed. Of course, these legal changes were constant, strategic, and ideological. I mean, similar trends are observable in many other countries, including Turkey. Just to give an example, the AKP government amended more than 12 times the constitution. And these amendments affected more than 130 articles of the Turkish constitution, which is, I think, made up of 177 articles. So, I mean, and again, regarding laws, till 2010, Hungarian governments in average passed about 400/600 laws or amendments dated, right? But in Fidesz times, this has risen to over 850 annually between 2010 and 2014. There are some other drastic numbers in the paper. And about 700 thereafter. So this means that there is always a legal and constitutional activism. And this, of course, makes impossible to oversight. It overwhelms, I mean, all opposition parties, even civil society organizations are all overwhelmed to sort of oversight it, to organize and mobilize opposition to it. It reduces transparency and accelerates institutional transformations before resistance can be mobilized. Another legal strategy of the Orban government and many other autocracies is the use of omnibus laws. These are fast-track legislative procedures. They are bundling unrelated too many laws, too many amended articles together, right? And so these laws serve to stifle political debate, limit scrutiny, and as bundling hundreds of legal procedures or provisions into single legislative package, I mean, it's exceedingly difficult for the opposition actors, as I said, to even understand it, to contextualize it, and to sort of organize political opposition. And even in some cases, even Fidesz parliamentarians do not know they are voting for which provision and what it really changes. Unfortunately, the use of omnibus laws is not only unique to Hungary. Of course, it's a torba yasalar. It's a very known in the Turkish practice. And if you look at the EU debates, even the EU Commission tends to use this kind of omnibus laws, and it creates some discussion there as well. There are some other legal strategies of the Orban government to accelerate lawmaking and to make it difficult, the political opposition. For instance, they have one-day procedure where members of the parliament are not allowed to propose amendments, effectively sidelining deliberation and opposition in that regard, because the law has to be passed in one day. Again, bypassing parliamentary debate with 2/3 votes. I mean, if the 2/3 of the parliamentarians say yes, the law can be passed without any real parliamentary debate. It's incredible, but this is real. So one of my interviewees has said that in some sort, I mean, Hungarian parliament became a law factory, not a deliberative institution. So there are some examples in the paper regarding omnibus legislation. I won't tell it, but very interesting stories. So here with the omnibus laws and other accelerated legislative procedures, of course, there are certainly too many goals, as I said, but the first one is is strategic opacity. So that controversial provisions are buried into technical legal mess, so that you can even not understand what is really going on, right? Of course, another legal strategy, restructuring the judicial institutions and judiciary overall. For instance, the retirement age for judges was suddenly lowered from 70 to 62 for senior judges. This meant the purge of retirement and is eventually purge of many senior judges. And of course, the empty chairs were filled with loyalists, right? They also created National Judicial Office with a lot of authorities and power. So its president gained authority over judicial appointments, promotions, disciplinary procedures, and all other important issues. So the result was not outright purge, actually, but a gradual reconfiguration of the judicial field. So here, I mean, we have two different strategies. And one is to reshuffle, reconfigure an institution. But in cases where institutions are resisting to bypass this institutional resistance, new and parallel institutions are created, right? So these same strategies can be observable in other contexts, in Poland, for instance, in Turkey as well. Putin do not need to do this thing. But in other sort of modular autocracies, because Russia is not even a modular autocracy, it's just autocracies. But in modular autocracies, like Hungary, Turkey, whatever, you either reshape an institution, but otherwise you create a parallel institution. Okay. Yeah, and the constitutional courts are often seen as sort of veto powers against the executive branch of the state. So they are targeted, they are neutralized. In Hungary, for instance, budgetary roles of the constitutional court were crippled. And again, its judicial review authority was highly restricted. For instance, it can only oversight any constitutional article or amendment. Just, it cannot oversight, it cannot make decision on the substantive side, right? So substantively, the constitutional court, Hungarian constitutional court, function no longer. It does not function in a way, as a meaningful veto player. I mean, it cannot rule out any constitutional amendment. The same was done in Turkey. State of emergency decrees. The constitutional court in Turkey cannot sort of oversight the emergency decrees and make any decision on if these decrees are opposing any constitutional article or not. Right? I'm not going into details because I'm not a jurist, so I don't want to make any mistake. Another strategy is legal ambiguity or ambiguous phraseology. So the government increasingly rely on vague concepts such as national sovereignty, foreign influence, moral grounds, national interests. So these are framed as part of legal discourses and even laws. Of course, these terms lack precise definitions, allowing discretionary enforcement, and also it is so easy for the government to use and abuse these laws. It can be subjected, it can be, any opposition party or politician could be targeted. This vague terminology also makes it the selective use of and arbitrary use of laws, right? For instance, there is a key example here. They established Sovereignty Protection Office, established in 2023. It investigates, for instance, foreign influence. But this, of course, is extraordinarily term. And everybody was, when I was in Hungary, Budapest was afraid of the fact that these will be used to target civil society organizations. Okay, do I have how many minutes? Do I have?
A few more minutes maybe.
Okay, a few minutes. The same happened in Russia, for instance. The foreign agent law. They passed this law, and it criminalized many political opposition and activists, right? In Turkey, we have anti-terrorism laws and 2022 disinformation laws relying on undefined, very broad categories, such as terror propaganda, as you know, false information. These are facilitating mass prosecutions of journalists, academics, and all other civil activists. So across all these cases, vagueness, ambiguity becomes a sort of legal weapon allowing repression without overtly breaking law. Okay, so just after all this, there are some broader conclusions. Right. Before this, as I said, Hungary is a modular emergency regime. You know, in because of the COVID pandemic, the Orbán government declared state of emergency, and they passed enabling act. This was very important because it recognized the government to rule the country via emergency for an indefinite time. Normally, all state of emergency cases are just extended by the parliamentary vote. Then, after various domestic and international opposition, they revoked the Enabling Act, but the same day, in 2022, they declared state of danger because of the Russian invasion of Ukraine. So, I mean, practically, I think the state of the danger, if I'm not wrong, is still in charge. And in Turkey, you know, state of emergency was declared after the coup plotted by Gülenists. We had 2 years of state of emergency. 37 emergency decrees were passed, and some of them are still in force, even if the state of emergency has been formally lifted. And some emergency decrees made permanent changes and amendments in the laws, right? And even we replaced the parliamentary system with the presidential one under state of emergency. And currently, Turkey is practically ruled through presidential decisions and presidential decrees. Right? In the paper, there are more details on it. So, I mean, this means that there is a sort of a global rise of the use of exceptional emergency executive powers. Governments are really used to it, and they really like it. And populist leaders especially like it because they hate any veto mechanisms, any parliamentary deliberations. They like very accelerated, fast-tracking lawmaking, right? And they are not also they do not want to be part of any real legal or political discussion. So that's why I said that this kind of modular emergency governance of countries are becoming widespread. Right? Okay, so just to conclude, we can say that Hungary and Turkey demonstrate a democratic erosion today, and this is incremental, legalistic, and procedural, right? There is continuous lawmaking and constitution making for the purpose. So legality is not inherently democratic, right? We know it better now. Law can be a tool of domination when controlled by autocratic legalists. These dynamics are global. Serbia, Venezuela, to a certain extent, China, India, and others exhibit the same kind of tendencies. And also emergency governance is becoming normalized globally, where normalcy and exceptionality blurs a lot. So today's autocrats are constitutional engineers, legislative entrepreneurs, or legal strategists. Thereby, in contemporary autocracies, law is not the victim of authoritarianism, but it is its infrastructure. Thank you very much.
Ayşe Hocam. Do you? Nasıl arzu ederseniz. Evet, yok. Can you hear me? Okay, what I will do, thank you, Alper, for this. I obviously read it in detail, and what I want to do is maybe situate this within the big literature that has been around for, I mean, I can say maybe almost 2 decades, really. I mean, increasingly getting more important. The past decade, maybe. We see this literature. So situate this within the literature and then maybe sum it up and then ask some questions for further discussion. That's what I'm trying to do. Now, from the 1990s onwards, I mean, we could say that democratic breakdowns have been taking place less by military coups and more by executive takeovers. In fact, there's a chart, April France has a book on authoritarianism, and she shows it, right? The military coups are decreasing in number, and what she calls authoritarianization is increasing. It is actually the elected incumbents that are subverting democracy. I mean, there is what I have back in 2019, what I earlier called, today there is an authoritarian zeitgeist in countries, from Turkey to the Philippines to India, Venezuela, Russia, Hungary, obviously. I used to include Poland, and now, I don't know, I don't, but, I will get to Poland later. Now, and also, of course, we see authoritarian practices in established democracies. So, it's the authoritarian practices that is increasing. The elections are competitive, but they're not free and fair. And political activity is on an uneven field, with incumbents' use of the media, resources, and the law for their own benefit, as Alper has been saying. So today, self-proclaimed illiberals have reduced democracy to elections and plebiscitary measures and use constitutions to amass power. Hence, it has become all the more important to study the mechanisms that they use for authoritarian consolidation. Now, according to the conventional understanding, authoritarian regimes, as Alper puts it, they are seen as outright lawless. But today they seem to be using the law, and in the words of Alper, legal systems in such regimes are not eradicated. Rather, they are transformed into mechanisms of political domination. I think among many other instruments of liberal democracy that they have hijacked
namely civil society, elections. They have also been hijacking constitutions and other laws. In fact, I have described these regimes as hijackers a while ago, back in 2021. They hijacked elections, they hijacked civil society, they form their own civil society and basically take over the area of civil society. And also they hijack laws, they hijack social media, they hijack the discourse of the Democrats, also interesting. So, yeah, they are hijackers. They have been hijackers for a while. And these developments have changed the meaning, the raison d'etre of constitutions. From instruments for framing basic rights, they have been turned into tools for authoritarian consolidation. Now, I always think of course, after the Second World War, when Hannah Arendt sits down to write this book, that's 1951, for The Origins of Totalitarianism, she basically says, with totalitarianism, it's a new concept. She was referring to the Nazi regime and also the Stalinist regime, right? She was, it's an attempt to describe these two regimes. And she basically says that she had realized that these regimes look like no other authoritarian regime that existed. That's how she puts it. She used the expression novel forms of government, actually, in that book. These are novel forms of government. And indeed, really, today, the regimes that we're witnessing are also novel forms of government. I believe that the way they hijack constitutions and other laws is their most distinguishing feature. If I have to really come up with the most distinguishing, they have many others, obviously. I believe this feature extends their term of government. And this crooked legality gives them undeserved credibility in the international arena. And since they stay in power for prolonged periods of time, these regimes challenge Adam Swirsky's famous expression, the very simple definition of democracy, where he says democracy is a system in which parties lose elections, right? They don't lose elections. So basically, they have replaced the idea of rule of law with rule by law, as it was expressed for the first time. It was in the title of their book, actually. In 2008, it was published, Rule by Law, by Ginsburg and Mustafa, one of the important works in the field. Now, of course, there is the expression autocratic legalism that initially emerged in an article on Venezuela by Javier Corrales. And he used this concept in his analysis of the Chavista regime in Venezuela, practically this. And Corrales refers to the use, abuse, and non-use of the law, use, abuse, and non-use of the law, in favor of the executive branch. Now, it was never clear in that article what he meant by non-use. But then I came across an interview that he had. This was during the COVID, the pandemic. Yasha Moon was doing these interviews with several people, and he had one. You can actually find it. Yeah, you write Yasha Moon in Javier Corrales, it comes out in Google. You can find it. And there they talk, and then actually he clarifies very clearly what he means by non-use of the law, and it's exactly what Alper also calls selective use. The selective use of the law, for the political opponents. And Alper basically says punitive use of law against opponents juxtaposed with legal protections and incentives for loyalists. End of quote. This is by Alper. So this is what they do: selective use. So use, they have used, and they also not used a lot when it's necessary. So later, in the literature, the concept of photographic legalism became bigger and wider with Kim Chappell's intervention into the field. When she used the concept by making references to the regimes in Hungary, in Turkey, in Venezuela, in Poland, and what distinguishes, of course, Kim Chappell's analysis, I think, is the emphasis she lays on how these regimes deliberately use legality and create new law as a way of consolidating power. So she underlines that deliberateness. And underlines that some constitutional democracies, she says, are being hijacked by a set of legally clever autocrats, or what she calls legalistic autocrats. Now, as an example to the deliberate use, I always think of actually Recep Tayyip Erdogan's ability to run as a presidential candidate, actually for the third time. Remember, in 2003, there were discussions about that. And this was actually enabled by the 2017 Constitution through the addition of the temporary Article 21, and Supreme Election Council approved it on the basis of this article and Article 1, which is the article on the election of the president, as well as another law 6271 on the election of the president. So the thing is that temporary law was added in 2017. So thinking about the elections in 2023. Okay? So actually, when I saw that, I actually knew that, this has a legal basis. They can report, they win. So it was legally, yes, possible for him to run as the president. And the decision about that was actually made back in 2017. So that's what I mean, an example of deliberate planning. So legalistic autocrats replace the liberal values behind democracy and constitutionalism with an openly professed commitment to illiberalism. Of course, as we know in the past, liberals were both for constitutionalism and democracy, and illiberals were against both. Right? Now we have something awkward. Our knowledge of political theory tells us that you have to have liberalism before a liberal democracy. That's the sequence in history. Leading to the emergence of the idea of liberal democracy in the middle of the 19th century. So liberalism precedes and is embedded in the idea of democracy, making the idea of illiberal democracy an oxymoron. You can't have something liberal democracy. It's not a possibility. Obviously, illiberal democracy became the slogan of today's populist leaders. Populism is not really the name of a regime. It's a style. It's a political style. Political style adopted by political actors in both democracies and authoritarian regimes. It's not only anti-elitist, it is anti-pluralist, and it actually reduces democracy to elections. Basically, that's the big consequence because it's anti-elitist. Now, the first question that I will pose is, how is autocratic legalism manifested? What is the manner? What is the style? How do governments engage in these practices? For instance, in the Turkish case, obviously, it's the decree laws, as Alper says, the decree laws that were there, the state of emergency, and they existed, obviously, part of the former constitution. Now they're replaced by presidential laws, right? And the decree laws, or the decrees having the force of law, they have always been omnibus laws. What is, as Alper puts it, sometimes they're all bundled together and they're called the salad law, right? I use that expression, the salad law. in 2019, is the expression for Hungary. And they contain packaged changes to the existing laws in unrelated areas, all bundled together. I bring this up because I remember seeing one, decree law about the elections. Okay, and the way it was put was, I don't remember the number, maybe I have the number. Yeah, the decree law 687. Okay, and when you look into it, I mean, there are all these articles that are actually on totally unrelated topics. And I always give this example. There was this one, it was about the penalty for snow tires, which was like a paragraph. A lot of explanation in that. There is Article 2 of that decree law. And then you go Article 10, it's 1.5 lines. It says such and such article of the law on elections is annulled. Now, you have to go out of your way to find what that article is. Okay? And that article actually, stops punishment for private TV channels and radio channels for not giving equal representation for the candidates. So the way it is done is very subtle. Right? It's very hidden, actually. So that's the first question. I mean, maybe then here you can see how it is done, the manifestations. That's the one question that I have in mind. Obviously, these executive decrees have become permanent features of the law. They have been integrated into the municipal law, integrated into the law in elections. They are everywhere. Now, Alper looks at the autocratic legal practices in Hungary after Fidesz established itself in governance after the 2010 electoral victory and forming a coalition with the Christian Democratic People's Party and securing a 2/3 supermajority in the parliament. Now, how it was done? Obviously, it began with amendments to the 1989 Constitution, yet continued with a new constitution in 2011. Which basically came into force in 2012 with the cardinal laws that I referred to. That cannot be changed. And then secondly, by dominating the media landscape. Thirdly, by promoting Christian and national values. Viktor Orban's speeches are particularly important on this. I mean, if you're going to follow the speeches of one autocratic leader, he's the one. And also, emulated by various other leaders in the world. The speeches are very clear, very articulate. So, and obviously, Sovereignty Protection Office established in 2022, criminalizing civil society. And also, as I've alluded to this, diminishing the authority of the Constitutional Court. And limiting the court's oversight to procedural matters. And then finally, again, I've alluded to this, damaging the independence of the judiciary. Now, one measure towards this was taken immediately after electoral victory in 2010. The retirement age of judges was lowered from 70 to 62, which is a major change in the which resulted in many judges retiring and being replaced by those close to Fidesz. Now, the thing is, and this leads me to the second question, a similar policy lowered the age of the judges in Poland, the law on the Supreme Court, but was reverted by the European Court of Justice in 2018. After which the retired judges went back to work. It was applauded back then. So the comparing Poland and Hungary on such issues, there's a lot there. There's a lot to be learned there. And Daniel Kellerman is one name who has been doing that for many years. And in a recent article that appeared in Journal of European Public Policy, February 2025 issue, he asks a question. He says, if the EU can the EU escape its autocratic trap? He says, And it concludes that although there has been some positive shift in EU's sanctioning approach to illegal governments, EU will not escape its autocracy trap anytime soon. Now, another article actually in the same issue underlines that sanctions actually have been emerging, not when EU values are threatened, but when EU common policies are threatened. So there is they actually underline that difference. So it seems as long as backsliding governments do not directly threaten common policies, the other member state governments seem to consider the policy costs of sanctioning backsliding as, prohibitively high, and therefore tolerate violations for values. This is what has been happening. So, basically, what kind of question this is going to be? Well, first one was, how is it that this manifests with the decree law? My second question that I want to ask to the panel is why the EU cannot escape this autocracy trap? Look at these dealings, this is very recent, right? Hungary threatened to veto, just now actually, 90 billion euros of EU loan to Ukraine. A similar thing happened back in, I believe it was 2023, and EU actually unblocked, I believe 10 billion euros that was geared to be given to Hungary. And European Commission now, they say advisor to top court recently said it was wrong to unblock that. So there is this threatening, right? This calls into question the credibility of the EU's commitment to its own fundamental values. It makes EU institutions vulnerable to blackmail by illegal governments. These are some of the examples, this was, I believe, a discussion in 2003 about Ukraine's accession to the EU, right? It involved that. So there was an effort to include Hungary in this discussion by unblocking funds that were actually withdrawn. And now, it looks like it was a mistake. Because Hungary continues to Hungarian government continues to come up with these threats. I think of not just the EU, of course, I also think of the Venice Commission, really. There's something, there's such a thing, right? The Venice Commission. It's, it is its function, its raison d'etre is to deal with these issues. But it has been failed to address this. Obviously, there's no need to repeat it here, but perhaps this should be the last point. According to the Freedom House, Hungary is the only EU member state whose status has been lowered to partly. So these are issues that doesn't just involve, but I think it also involves the EU. So I will leave you with this. The second question was also clear. It was too large, but maybe not fair, Alper, but take it.
Thank you so much, Ayşe Hocam. Alper Hocam, would you like to respond to these, or would you like to come back to them at the end?
Yeah, maybe at the end, because
Okay, and that will also give you some time, perhaps, to think about the answers, since they were pretty strong points. Ece Hocam.
Okay, I will share my presentation here. Can you see my presentation?
Yes.
Okay. Hi everyone. Thank you for having me here today. I will give my talk on chaos and uncertainty, but what are the words of philosophy and social sciences, but as well as the law. And as a lawyer, my framework will be naturally the constitutional law, and I will a little bit fall apart from the speakers before me. Firstly, I will, sorry. First, I will try to give an overview on the principles of the rule of law and the constitutional democracy. As you well know, the principle of the rule of law belongs to one of the unamendable principles of the Turkish constitution in Article 2. And the constitutional democracy, on the other side, is composed of several sub-principles, which gives a political system its character as an integrated package. These two principles make my orientation point, since the job of the lawyers is to measure the proper subsumption of the facts to the norms and the principles. It's not a judgment on a political fairness or political appropriateness. I will not include the COVID phase in my presentation, even it was a state of emergency, but an official state of emergency was not declared. The 2 years between 2020 and 2022 deserve a different and more intensive examination of the concept of the state of emergency. I would just like to say briefly that it was no coincidence that no state of emergency was declared during this COVID period. Authoritarianism has a long-standing memory and knew from the period 2014 to 16 that it's possible to rule without a legal basis, and that this fools more uncertainty and fear than a legal framework can eliminate. I will focus on two basic documents to explain the principles of the rule of law and the constitutional democracy. The first is the Charter of Fundamental Principles of a European Democracy of the European Law Institute, for which I also served as a consultative committee member. And the second document is the updated rule of law checklist adopted by the Venice Commission on December 2025. Firstly, the fundamental constitutional principles of a European democracy. As you see, the rule of law principle is a subtitle of a constitutional European democracy, and a constitutional integrity includes also a sub-principle on the state of emergency regime. What are the crucial restrictions on a state of emergency regimes under this charter? In short, only what is necessary for my talk. It must be strictly It must be strictly limited to what is necessary. We name it the proportionality principle. Its exercise must be subject to judicial review, whether a normal judicial review or constitutional review. It may not derogate from non-derogable rights and may not affect the essence of fundamental rights. The Constitution must not be amended during a state of emergency. See the constitutional amendments 2017, as mentioned by Professor Kadıoğlu in the state of emergency time after the attempted coup d'etat. I will come back to these restrictive rules. Important to mention is the emergency clauses are also present in the European Convention on Human Rights in Article 15, to which Turkey is party since 1953, and recognizes the judicial authority of the European Court of Human Rights since 1991. And this emergency clause is also existent in Article 15 of the Turkish Constitution. Secondly, the updated rule of law checklist of the Venice Commission is dedicated to only one principle of a constitutional democracy, but also there exist several intersections. The state of emergency has been handled in this report as a special title associated with the following restrictions. It should be implemented, the state of emergency should be implemented under parliamentary control, and judicial review should be possible of the existence, duration of the state of emergency situation, and of the necessity, proportionality, and temporariness of individual measures adopted during the state of emergency time. Even in a state of emergency, the fundamental principle of the rule of law must prevail. This extraordinary situation is also not a ticket for free for a lawless time in a democratic state. Necessity, proportionality, and temporariness of all measures is the core condition of any emergency regime. I have to mention that both documents, the rule of law document of the Venice Commission and of the European Law Institute, are soft laws, but these principles have been interpreted and developed as main pillars of the Turkish constitution, also through the Turkish Constitutional Court as well, and they are binding interpretations for all state organs in Turkey. Now we can take a look at the state of emergency regimes of the last 12 years in Turkey and the compliance with or violations of the mentioned principles. But first of all, I would like to show the models of the state of emergency regimes which began with the Rome state tradition. That is the provisional, it is named the provisional dictatorship. The other alternative could be the sovereign dictatorship, which was theorized by the German lawyer Carl Schmitt. The aim of the Rome model of state of emergency is to maintain or re-establish the existing regime, limited to a specific period, usually up to 6 months. And we read all these principles and the model of the Rome situation in many constitutional court decisions and case books and monographies in Turkish literature. The dictator is outside the regular legal system. The procedure for appointing the dictator is laid down in the constitution and in the regular organs. The separation of regular offices from those of the dictator is the main feature of this model. Senate versus dictator, praetor versus dictator, which is not in accordance with the modern state systems. The second model is the Anglo-Saxon model. In this model, the regular legislature decides on the exceptions and enacts laws to eliminate the reasons for the state of emergency. However, the measures and emergency laws exist alongside the regulations that apply to ordinary circumstances. We see it in the North Ireland legislation for 20 years, or the Patriot Act after 9/11 attacks in the USA, or anti-terrorism law 1991 in Turkey. Even if the state of emergency is declared for an indefinite period, which is also not the case in the Turkish case, the regular offices are always kept separate from this part of the state activities. Now we come to the Turkish model. The Turkish model is a mix of provisional dictatorship and the legislative model. Provisional because the state of emergency aims to restore the regular status quo, but there is no separation of the offices that declare the state of emergency and introduce the measures. It's in the Turkish model, it is always the executive branch. But on the other side, there is a parliamentary control, but this parliamentary control is either in the parliamentary system or in the state presidential system, a weak political control. And near to the legislative model, as the legislature also makes or can make exceptions in parallel to the regular state provisions. Here, shortly for reading, the unamendable clauses in Article 2 of the Turkish Constitution and Article 15, which regulates the constitutional provisions on the state of emergency. That are the core rights. They cannot be violated even in the state of emergency regimes. Prohibition of tortures. Torture is one of the important one. And here, the new regulation after the constitutional amendment 2017. It is compromised from the articles 19, 20, and 21 in the former constitutions, but the logic stayed the same. There are two categoric reasons to declare the state of emergency regime. That there are the security reasons, the natural reasons, and the economic reasons. But it's very interesting to note that a state of emergency has never been declared in Turkey on the ground of economic crisis. The reasons were mainly security reasons, and rarely natural disasters, as we see for the last time after the earthquakes 2023. And then it's much more. Okay. And then the jurisdiction of Turkish courts, not only the Constitutional Court, but also the Council of State or Danıştay, has made jurisdictions on the nature of the state of emergency in the 20th century. And under the Constitution 1982, the Constitutional Court has slowly but steadily developed a body of case law consistent with the rule of law principles. And I will show you the key moments and the points of this case law. The very first ruling of the Danıştay was groundbreaking because it was the first time under the now Constitution 1982 the state of emergency regime had been subject to the constraints of the rule of law principle. And the Council of State ruled that all civil servants and public officials who had been suspended from duty based on a decision by the competent district officers, which were mainly military, had to return to their previous job after the end of the state of emergency, because the duration of the measures under this regime was limited to this period and couldn't have any legal effect beyond it. Please keep in mind, we will come back to this timely limitation. And as I said, also the Constitutional Court has developed a slowly case law about the regime, and the main findings are despite the expanded powers of the executive, even a state of emergency regime is a legal regime under the rule of law. The emergency decrees may not exceed the objectives and the limits of the state of emergency, and as measures may only concern its operational aspects. And emergency decrees may not use to amend laws as they are operational in nature and cease to apply once the state of emergency is lifted. However, in this time, in the 80s and 90s, several laws were amended through emergency decrees, and that was a breach with the principle of the rule of law by the parliamentary majorities. And following the case law of the Turkish Constitutional Court until 2016, the emergency decrees are limited to the reason for and purpose of the state of emergency. Their content is therefore aimed at eliminating the reasons of the declaration of the state of emergency and limited in terms of time and location. This means the measures taken and legal regulations enacted during this period only apply in the districts where the emergency regime has been declared, and only during this specific period. And then I would like to come back to the constitutional integrity, which was mentioned in the European Law Institute's paper. We call it the Constitutional Court is not bound by the designation of a statutory instrument by the executive branch. This means that if the statutory executive branch says it's a decree, it's an emergency decree, even then the Constitutional Court has the competence to investigate whether this decree has the quality of and the aims of the emergency regulations and meets the requirements of a state of emergency. This view must take into account not only the constitutional provisions that directly concern Article then Article 119, but also the constitutional rules as a whole. That means the constitutional integrity is the main principle in the interpretation of the regulations. And then I would like to come to the non-declared state of emergency regime in the southeastern part of Turkey between 2014 to 2016. The reason was of the military actions was the mass protest in the southeastern part of Turkey with many Kurdish populations against the siege of Kobane in Syria. And without declaring the state of emergency, the governance and district governance, valis and kaymakams, had imposed around-the-clock curfews without time limits. And it was the first time, even after the military coup in September 12, 1980, only a curfew between midnight and 5 a.m. was ordered, and the longest curfew to date lasted 33 hours. And in the time as of 2014, we have seen curfews for the duration of up to 1 week. And at that time, we have to mention it for a effective remedy. The second elections to the High Council of Judges and Prosecutors had already taken place, and that means that the judiciary was under the control of the ruling party. So the effective remedy was not a real effective option. And then the allegedly legal basis was the Provincial Administration Law, İl İdaresi Kanunu, Section 11 and 33. And the wording was officials, that means the governance or the governors or the district governance have a duty to maintain peace and security within their area of competence. And the measures of a curfew is not mentioned in all this administration law. And the Council of Ministers failed to declare a state of emergency and act as a regular executive branch. Even there was a special and urgent need in these cities to declare the state of emergency. Also to guarantee the legal standards for protection of the fundamental freedoms and rights of the people. And in summary, a total of 60 curfews have been imposed in around 20 cities. More than 200,000 people are directly affected and have had to leave their homes. And officially, these are the official numbers. The Human Rights Society and the Human Rights Foundation gives other and higher numbers. Officially, 460 civilians have been killed in this time, where the state of emergency was not declared. What was the effect of this deconstitutionalized state of emergency regime in that time? No effective remedy. The lawsuits filed with the district administrative courts were unsuccessful. Applications for interim measures for the Constitutional Court were filed, but the court ruled that the district government has justified the enactment of this measure for the purpose of arresting terrorists and protecting the safety of the population by killing more than 400 people. And that in light of this, it couldn't be claimed that this purpose didn't constitute a basis for the executive action, but still no declaration of the state of emergency was made. And to name the chaos, to the last declared state of emergency regime, following the attempted military coup d'etat on July 15th, 2016, 6 days after the officially state of emergency regime was declared, and the derogations from the treaty obligations were notified to the United Nations and the Council of Europe. And in the 2 years of the state of emergency regime, 32 emergency decrees have been issued, and almost after 2 years, all of them had been approved by the parliament with slight changes. And I have actualized my notices yesterday for this talk. By date, 113 rulings of the Constitutional Court in thousands of pages has been published, and these rulings have declared the laws approved by the Parliament as a law, as an ordinary law, declared this as completely or partially unconstitutional, and there is no purge overview of regulations in force from these state of emergency laws. That means no one can say which measures and which regulations are still in effect and which were unconstitutional, which were completely unconstitutional, and how was the argumentation of the Constitutional Court. No, even the constitutional judges can summarize their rulings on these emergency decrees and laws by heart. And then what was in quotation, the executive branch was very creative in finding special emergency measures in this time. For the first time in Turkish history, even including the military coups in 1960, 71, and 1980, emergency decrees were used to dismiss people from public service without a personal administrative act. You had to find your name if you are dismissed from a public service at an appendix of the emergency decrees, and approximately 152,000 people are affected from these dismissals. Criminal, administrative, and civil liability exemption for those public officials who were involved in the decision making and implementation of these emergency measures, and that is it's factual amnesty for these public officials even if they are violating the fundamental rights and freedoms of the people who were affected by these measures. And several amendments to the Code of Criminal Court Procedure were made. The duration of police custody and pre-trial detention were longer than usual, and visiting hours for family members and lawyers were regulated other than in the normal times. And even in the academic area, no academic activities such as habilitation, docentic process outside the university were possible. It was permitted even for those who have been dismissed and those against whom criminal proceedings are still pending. The rule of the assumption of innocence didn't work in that case. And no possibility of returning to the original university in the event of exoneration and reinstatement, and cancellation of work licenses, for example, for the teaching staff. And then many others, travel ban and cancellation of passports of public officials, but including, of course, those of spouses, uniform clothing, work codes for prisoners before appearing in the court, and amendments to approximately 155 laws and over 300 new regulations with emergency regimes were acted. And there are no restrictions on the subject matter. In one emergency decree, there were regulations from traffic law to criminal code or code of criminal procedures, and think of the principle of limitation to necessary measures. To the effective remedy, there were no effective and timely legal remedy available. There were a commission to review measures taken under the state of emergency were established. The commission consists of 7 members and had to deal with over 120,000 applications, and then followed by the decision of this commission, you have to go to the administrative courts in Ankara. There are only 2 chambers, and then you have to go to Danıştay, to Council of State, and then you can make a constitutional complaint to the Constitutional Court, and finally you can go to the European Court of Human Rights, and that approximately you have to need a time of 10 to 12 years to have a decision, binding decision by a Turkish Court. It was almost the same as in the time in Germany between 33 and 45. Braher, a very famous German historian, said an organized delaying tactic or controlled confusion, which was the case in the 30s and 40s in Germany. And Ernst Frankl, a famous German historian and political scientist, said bureaucratic lawlessness. It is bureaucratic done by state, but it's lawless, and the state doesn't belong to this lawlessness. And the Constitutional Court abandoned itself and gave up the case law from 1991 and 2003. And the court sees the purpose of the constitutional roles as protect and maintain the democratic legal order, but says at the same time, although the constitutional limits are imposed on the executive branch in a state of emergency, judicial review by the Constitutional Court is impossible, even in a state governed by the rule of law, as the court would have no competence to do so. So it is a declaration of the Constitutional Court to abandon itself and its own competences for an effective judicial remedy. And then the four decisions rejected all the applications, and only after the Parliament has approved the emergency decrees to a regular law, the way to the Constitutional Court were possible. Then and there were also a continuation regulation after the end of the emergency regime. Exceptions valid for 3 years were made in several laws, extended periods of pretrial detention, and in the Code of Criminal Procedure, the Public Prosecutor's Office is on an equal footing with judges in terms of several powers to take measures. Restrictions on the legal consequences of decision made by the Commission for reviewing these measures was made. And the interplay between the Constitutional Court and the European Court of Human Rights is still ongoing, because after 10 years of declaration of the state of emergency, the European Court of Human Rights has decided on hundreds of so-called bylaw cases for violation on the principle of no punishment without law, guaranteed under Article 7 of the Convention. That means the Constitutional Court rejected these applications as in line with the Constitution and the European Convention before. And despite these violation decisions, there are hundreds of them, the Constitutional Court is still not able to decide on a rational and non-contradictory basis to follow these decisions from Strasbourg. And the consequence is a completely uncertainty about the criteria and trials on a legal and fair basis in cases of these bylaw accusations. To conclude, the rule of law in the European sense is based not only on written, but also on many unwritten principles. And the factual and legal state of emergency practices in Turkey in the last 12 years have undermined the fundamental principles of legal certainty, the presumption of innocence, and many core fundamental rights and freedoms under the Turkish Constitution and European Convention of Human Rights. The years of well-established case law by different courts, and at the end by the Constitutional Court itself, finally abandoned after the attempted military coup 2016. And arbitrary political decisions against the Constitution are accompanied by court rulings that lack any reasoning. The arbitrary measures conducted in emergency decrees and ultimately in laws are creating a climate of fear also within the judiciary. The arrest of 2 constitutional judges and several high court judges immediately after the coup d'etat attempted military coup serve as examples of legal uncertainty because the procedure was not upheld. Any improvement in the independence of the judiciary can only be based on principles, but not only on political pragmatism. And the potential political control mechanism do not exist either normatively or in fact. All state functions are merged in one person after the Constitution Amendment 2017, and other institutions have voluntarily relinquished their normative functions and submitted them to the executive power. And despite the eternity clause, the constitutional amendments of 2017 brought about a legal revolution. This term was used for the Machtergreifung in Germany of the Nazis in 1333. And at the end, we can speak of a constituent power based on an authoritarian state structure. Chaos, uncertainty, and fear of state actions are the main characteristic of the new public order, and I think it would stay if the constitution does not didn't abolish, and a democratic state is, for my view, not possible to rebuild the democratic state is not possible under the circumstances of this structure in the last, what we have seen in the last 9 years. Thank you.
Thank you very much. I think great overview and survey of the whole legal foundations of where we are today. And that's been very valuable, also a complement to the discussion that we've had so far. So without further ado, I'm going to turn to Professor Atilla Atal now to give us more of the contemporary state of affairs in Hungary.
Thank you for your attention. Can you hear me?
Yes, we can.
Thank you. I am trying to share my screen. Probably you are able to see it. So thank you for this very, very wonderful event. Thank you for organizing this. And I am trying to speed up my speech, given the fact we have limited time. But my task here is to make a little bit deep understand, in conjunction with the Hungarian case, the authoritarian law in Hungary. It is a postdoc research, and my task here is to understand the political theoretical background of autocratic legalism, authoritarian legal structure in Hungary. So I am a man of theory. I'm trying to combine the political theoretical side and also, of course, the empirical side. I'm totally agree what we have heard about the interwar period. In conjunction with my research, it is a very important outcome that we should put a huge emphasis on the interwar period to make a deep understand of our zeitgeist in conjunction with autocracies, in conjunction with the emerging autocratic legalism. In this sense, a very important author here, they mentioned Carl Schmitt, and a very, very important point of the Schmittian political and constitutional agenda is the political sovereign, and how this political sovereign is able to create direct legal structure. So this would be my main outcome in this short lecture, that in Hungary we literally say that the political sovereign is able to create a legal structure, so directly creates law, as Schmitt argues in 1934. First thing first, I would like to put an emphasis on the theoretical background of authoritarian legalism in Hungary. After that, I am trying to put a little emphasis on the empirical side, how the Hungarian structure, legal and constitutional structure, has been weaponized because it would be my other point here that the main outcome of this sovereign lawmaking procedure is the weaponization of the constitutional and legal structure as a whole. And after that, I would like to put an emphasis on some food for thoughts and the further steps of my research. So, in this postdoc research, the main analytical structure is to make a deep understand of the Orban regime's authoritarian legal structure, and a very important question here: how the Hungarian constitutional structure and, of course, the Hungarian fundamental law became a weaponized structure. And in this sense, as I mentioned before, interwar period matters so much. I am trying to combine the political, theoretical, and constitutional theoretical elements of constitutional dictatorship. In this sense, I put an emphasis on the authoritarian legalism, the mentioned concept of Ernst Frankl, the dual state, and of course the contemporary populist constitutionalism. A few words about that. The authoritarian legalism is about Kimlin-Shapple concept, which is trying to make a deep understand in terms of a huge controversy, because on the one hand, in autocratic legalism, in current autocracies, we have seen a political majority on the one hand, but on the other hand, this means some kind of democratic formalism or rule of formalism, because in a deep understand, these political regime are working and as autocratic machines. So in this sense, we do not see some kind of substantive or normative side of constitutional requirements. We can see from legal perspective a pure legal positivism on the one hand. On the other hand, we have seen a lack of moral and substantive constitutional structure. And this is a very, very important and dangerous phenomenon. We have seen it in the Turkish case, that from legal perspective, the legal structure is trying to create its legal structure, but there is a huge controversy inside because the formal legitimacy and legality creates a huge paradox. On the other side, we have
Sorry,
spoken.
we cannot see your slides. We are at the first page.
Oh, excuse me, just in other way.
Yes,
Probably
we are
it's
now
not,
at page 10.
the full screen doesn't work. Okay, sorry about that. So we have seen it, the autocratic legalist structure before, and we are seeing the dual state. You have seen it. You are seeing it.
Yes,
Probably.
we do now.
Yeah. Okay. Sorry about that. I am quit of the full screen mode. So the next concept is dual state, the mentioned concept of Ernst Frankl. I am pretty sure that this concept of the interwar Nazi regime is very, very useful to understand the current situation in contemporary autocratic structure, because the mentioned perceived normality is the surface, but inside the prerogative state rules all the structure of everyday life. So as I mentioned before, this prerogative state is ruled by the Schmittian political sovereign, and as I mentioned before, it is a huge paradox between the two sides of the dual state. So the normative state as a surface can be seen as some kind of democratic or quasi-democratic structure, but inside, because the mentioned lack of normality, the mentioned lack of normative structure, the prerogative state is ruling as some kind of autocratic machine. And in terms of contemporary populist regime, we can speak about some kind of populist approach of constitutionalism elaborated by not just, but foremost by Paul Blocher. in terms of populist constitutionalism, it is a very important critique of liberal democracy and liberal constitutionalism. And populist constitutionalism means in some manner some kind of everyday aspects of constitutional structure and a radical reinstitutionalizing and reinventing the constitutional structures from, for instance, the constitutional court or the interpretation of fundamental rights. So these patterns or pillars of constitutional dictatorship is also very important. But at the end of the day, we can speak about some kind of constitutional dictatorship, which is also a very important concept of Carl Schmitt, and not just in the Schmittian concept. There are several authors, for instance, Clinton Rossiter, put an emphasis on that the legal decisionism is a core part of the critique of liberal constitutionalism and the unlimited power of the political sovereign, which is constrained by the agenda of liberal constitutionalism. So, in this sense, take a look at the Schmittian concept of Clinton Rossiter. It is very important that in the case of emergency, in the case of uncertainty, we should put an emphasis on to sacrifice all the constitutional and normative structure. Of course, democracy itself, Rossiter argues, to save our political sovereign. How to apply this pattern to the Hungarian case? As I mentioned before, the main outcome here is the weaponization of the legal structure, the weaponization of constitutional structure. We can speak about some kind of lawfare in the phrase of George Kennedy's assumption in conjunction with the weaponization law. And unfortunately, the Hungarian case is some kind of never-ending weaponization using the political and constitutional tool of constitutional dictatorship. I put an emphasis on three main assumptions, three main pillars of this constitutional dictatorship: the enemy creation in conjunction with the migration question, the biopolitical assumptions of the Hungarian regime in terms of anti-gender politics, and the mentioned well-based constitutional well-based structure of extraordinary governance measures. Unfortunately, we have seen the Hungarian case as a well-structured constitutional dictatorship. Alper mentioned that we have seen 15 amendments of the fundamental law. It is also very important how the last decade can be seen as some kind of authoritarian evolution in terms of amending the Hungarian fundamental law. From 2015, we have seen the main target here of the regime was and is, of course, the migration question, and the anti-migration structure of the Hungarian fundamental law is remarkable. And of course, in terms of the culture war, which is also very important elements of the Hungarian regime, we have seen it that the anti-gender question has been incorporated into the Hungarian fundamental law. The biopolitical structure of the Hungarian fundamental law, the declaration on the structure of marriage, the declaration of the biopolitical attitude of the political regime is very, very remarkable, and I would say unprecedented from constitutional perspective. And of course, the foremost important and well-structured constitutional dictatorship is the mentioned extraordinary governance structure in Hungary. Just very briefly, we have seen three main stages here, and it is also very important. We have to speak about, after Giorgio Agamben, a never-ending situation of state of exception. The Italian philosopher revealed that this is a never-ending and overlapping situation of extraordinary governance measures everywhere in the world, and especially, unfortunately, in Hungary. The first one is about the mentioned crisis caused by mass immigration, which is still in effect after 2016. So we live in a decade in the light of extraordinary governance measures in Hungary. It has been extended 20 times. Unfortunately, the COVID period just very briefly proved to be a very important blueprint how to create a constitutionalized structure of extraordinary governance measures. I will put an emphasis on that. And the last one is also overlapping with the mass immigration situation. This is the Russian aggression in Ukraine. It also has been extended several times, and the upcoming election is under the light of mass immigration and the state of emergency caused by the Russian aggression in Ukraine. So this is a double state of exception in Hungary, which is a long shadow of Carl Schmitt in several manners. But unfortunately, as I mentioned before, and I totally agree with Alper's analysis, this is a constitutional and institutional engineering because the Hungarian government put a huge emphasis on the constitutional micromanagement, and the 9th and 10th Amendment of the Hungarian Constitution were about to create this institutional framework of extraordinary governance measure. We have seen several unprecedented phenomena in the Hungarian constitutional framework. On the one hand, the universal right of the executive power making regulation all kinds of extraordinary situation. It is totally unprecedented, and we have seen a very dangerous and unprecedented phenomena making regulation even before the declaration of state of war and state of emergency. So this is a totally unprecedented phenomenon in the Hungarian and of course the European constitutional structure. At the same time, we are witnessing a very low standards of protecting human rights in these periods. And in a Schmittian sense, this is a pure domination of executive power, all kinds of extraordinary governance measures. What is to be done in this very sad framework? We have to put an emphasis on that this neo-Schmittian approach of governance is, of course, not an unprecedented phenomena, but in Hungary, it is highly dangerous that the weaponized legal structure, the weaponized constitutional structure can endanger the Hungarian citizen. Anyone can be subject to this weaponized constitution, not just from the perspective of political propaganda, but from the perspective of the everyday life. As I mentioned before, the interwar period matters so much. In this sense, what we are witnessing here is, in a Schmittian sense, this is a triumph of the political will. The law is the political will of the political leader. So this is a very important phenomena and outcome of the Hungarian model, that the mentioned Ernst Frankl concept in terms of dual state is a very important contemporary phenomenon in Hungary. The prerogative state works in Hungary and producing, on the basis of 2/3 majority, the new constitutional structure. So this is a new kind of crisis, or a high-level crisis of normality and legal normativity, which should be, on the one hand, analyzed, heavily analyzed, but on the other hand, we have to have our counter concept in terms of the will of the political in the Schmittian sense. Thank you for your attention.
Thank you very much. Now, since we don't have too much time left, so I am going to turn to Alper Hoca at this point for him to, first of all, respond to some of the points that were raised by Professor Kadolo, but also, his possible remarks or thoughts on what we've also heard from previous speakers.
Thank you very much. First of all, I have to really apologize as I have to leave in 5 minutes. Normally, I shouldn't do that, but it's not in my hand. Aisha, you have raised very broad issues, really. But what really I sensed from my old readings and your points and all other experiences is that, my paper and others, we often think in the model of legal engineering. We exhibit how autocratic leaders are using legality for their political ends. So this is in a way legal instrumentalization of law by politics, and it implies a kind of hierarchical relations between law and politics, where law is subordinate to politics. But autocratic leaders now are achieving more than this. So in a way, they colonize politics through law, right? So law is becoming so dominant that the legal reasoning, legal justifications, discourses of legality infiltrate everywhere. And law now sort of determines the legitimate spheres of politics. As we know it from Turkey very well, countless of court cases are open to opposition parties, opposition leaders. They are in jail. And so political let me say, race is reduced to sort of legal reasoning, legal judgments, and or cases of lawsuits. So when you sort of criticize any wrongdoing of the government, they just respond that, okay, well, we are just complying to rules. We are realizing what laws are saying to us, right? So you ask, how do autocratic leaders engage with all these? Yeah, they successfully not only mobilize laws, they successfully not only create a legal engineering model, but more importantly, they created a sort of discursivity, a sort of polity where law colonizes politics. And hopefully I'll try to engage with that. The second question regarding how EU deals with autocracy trap, this is not I can really respond to. I'm also thinking about it, and I'm sure Sanam will have much more mature thoughts on this. Time to time we also discuss this, and in our an article that we co-authored, we reached a different, similar conclusion that EU do not react if it's endangering its very identity and policy. This is very important discussion. Yeah, my response, unfortunately, is just that to this question. Yeah, I really apologize again, as I have to leave early, but I thank to everybody, to the audience and to all speaker guests, as you made this today possible. I'm very happy as I have the opportunity to discuss my paper and other thoughts here. Thank you very much.
Thank you, Alper. I still think that we should open the discussion to the floor since we have people here and get their questions and comments, and perhaps, you know, with our remaining speakers and discussant, and we'll see if we can respond to them in any way that we can. Yes.
I have a question. My name is Zeynep. I'm a research assistant at Sabancı University, and I'm a political scientist as well. I was thinking about whether we can identify some institutional scope conditions for this concept. I mean, is this autocratic legalism something that we can observe in all autocracies, or rather can we think about some institutional or historical prerequisites, such as a period when a genuine constitutional contestation took place, or more or less established political parties, or some traditional constitutionality. This is my question. I mean, is it a phenomenon that we can observe in all autocracies, or rather we see that we observe this phenomenon in some autocracies with certain institutional and historical prerequisites, as I said. Thank you.
Thank you, Zeynep. Maybe a few other? Şeyler söylemek ister misiniz?
Well, I don't know if you can make a distinction in terms of whether these practices exist in all autocracies and not in other. But what we're emphasizing here, I think, is, you know, the speakers and Alper, is that this is a trend. This is increasing in numbers, I think. And also they are copying each other. That this is also happening. I know several cases, you know, where, I mean, really direct copies of policies, you know, so I feel like they're going to have annual conventions or something at some point to, you know, exchange notes, you know, the leaders of these issues. And believe it or not, they are. Actually, I mean, most of these political parties, most of them, of course, interesting, except for the Turkish case, they are anti-migrant political parties. That's what they have in common, right? And they meet and they, you know, they exchange notes. So this is a trend. But you see, the thing is, these are practices. They exist also in established democracies, as I was saying. So it is the use and abuse of the law that is of interest here, I think. But the precursors of, I mean, is there something that it makes it more possible in some cases? I think that's what you're asking, and that's a legitimate question that needs to be researched.
Anybody else? Maybe I can say a few things about the EU dimension, which Alper has kind of but to me. I mean, this is something that I've been writing about as well, and my hunch and findings in the context of other research suggests that, but of course, if you look at the EU is not monolithic. So you have to look at the institutions. So in the council, you have the member states, in the parliament, you have, again, member states, but more from different political parties, etc. So there are different dynamics. I mean, council, of course, is crucial, the member states themselves. And I think that the core member states, such as Germany, are very status quo powers. They do not really take action unless they perceive significant threats to their own domestic order. Could be political, economic, societal, etc. And so they don't want to take the risk. They don't want to do the hassle or, you know, deal with the repercussions unless there is they perceive an existential systemic threat to their own domestic space. And I think that also conditions the way in which they approach democratic backsliding, in the neighborhood as well, not just within the EU, but also towards Turkey and other countries. Because once we've done this, we've published an article in German Politics last year about Germany and how it responds to Turkey's, autocratization, and then basically you're seeing a pattern, through the methodology that it only takes action when it perceives its own existential security or interest at risk. Otherwise, it prefers the status quo no matter what. It doesn't want to ruffle any feathers. And Germany is important because it's one of the core driving countries of European policies and integration. So that's the council side. And I think at the parliament side, these political parties and movements have really capitalized on their size and how their size matters to different political party groups, mainstream groups, mostly on center-right. They really harbored, for instance, Orban's movement for so long because they wanted to be the largest political group in the parliament. Right? Exactly. So it's taken years until the EPP finally kicked Orban out, and they didn't even kick him out. He knew he was going to be kicked out, so he sort of left and formed his own thing. So there are institutional mechanisms, and also I think nation-state interests that really favor the status quo, which makes life much easier for these kind of players. And legally speaking, there was a recent, again, Kellerman wrote this more recently. He wrote a piece about the whole legal setup of this that I also teach in my class. Basically, the legal mechanisms are there, that they've always been there. But the Commission keeps on coming up with these new monitoring systems, etc., that are so unnecessary. But they do it because they want to look like they're doing something. But the thing is, they don't activate, or they don't really try to activate what's already there. And the member states don't have their hearts in it as well. Even when they were establishing Article 7, the nuclear clause, which enables them to suspend, country because they're no longer democratic. He basically argues that the way in which it's phrased and it's put there is put in a way in which it's never going to be instrumentalized. So the member states, even from early on, never really intended to use that article. So they've always been cautious. Because, who knows what can happen if something goes in their own country. So it's like, I think, so his argument is because they don't have it in them, because they never want to anyway. So that would be my response to your question. But of course, it's a very long discussion that we can have on this. But Ece Hocam, would you like to come back to any of this?
Yeah. I'm not so optimistic about this. I only to say some words on Germany, because I think all democracies need, at the first instance, democrats and a minimum standard of economic wealth and a non-corrupt elite, leading elite. And there is no standard recipe for a good functioning democracy. You need real democrats in a suitable flora fauna. Guess in the coming in this year 2026 there are 5 elections in the states of Germany, and the German people are afraid of the fact that the AfD could get form the government in these 5 states who will make the elections. And guess what would be happen in almost 3 years in the general elections in Germany, and all the societies are not getting from today tomorrow autocrats, but they if the need for more authority and the less economic wealth is there at stage, they vote for autocratic leaders. And if the same party gets the same votes in 2 elections in line, what will be left from the so-called German firewall against the far right? I'm very interested in this in the elections this year, and I'm pretty sure that also Germany, as a status quo state and with strong institutions since the end of the Second World War, is at stake with the danger of getting less democrat. I wouldn't like to say more anti-autocratic, but less democrat. It is not taken for sure.
Thank you. Yes, I think it is a huge concern as to what happens in Germany, and some say they're polling at almost 30%, which is a huge number. And of course, then you have the age-old dilemma that we've always had when we've been discussing in Turkey and elsewhere, what to do with an anti-systemic political party that has so much public support. So isn't it anti-democratic to keep them out of the system, or do you keep them in the system? I have this discussion with my German colleagues a lot, and sometimes colleagues who are now politicians, and they say, well, no, there's a firewall, it's never going to happen. But then doesn't it also grow them? Doesn't it sort of flourish them, boost their power? Because it validates the argument that they are the anti-system ones, and look what the system is doing to them, even though 30% of the public vote for them. Mm-hmm. So this is a difficult argument to get out of, I think.
Yes.
And because they're now so well crafted in hijacking the institutions of law, which is what we've been discussing here for the past 2 hours, that I think everyone, the firewall, people argue in Germany, especially the Democrats, that we should keep the firewall because they're going to do what all the others are doing. Like what Meloni is doing in Italy today. Nobody talks about it, because she's towed the line on foreign policy on Ukraine. And so she started to cripple fundamental rights, starting with the right of association, etc. But then nobody talks about, well, there are people who talk about it, but their voices are so marginalized because Meloni has become this important political foreign policy figure that even replaced Macron and is sort of steering Europe with Merz these days, with Germany. AfD also, they might toe the line on foreign policy, look a bit more pro-systemic, and then play the long game. And, they might be able to do that if they deliver. So that is the big risk. Professor Antal, would you like to add to this discussion or anything else that you'd like to comment on?
Thank you. Just 2 things here. We have spoken about the patterns, the models of autocracies, and how the autocratic states and political leaders are learning from each other. It is a crucial thing, at least to my intention, because the emerging connection between Orbanism and Trumpism is a huge threat here in conjunction the transatlantic scales of political and legal structure of democracy. So that is such a thing, I would say, which can be called some kind of internationalism of right-wing authoritarian forces, or in other scales we can speak about some kind of internationalization of fascism in several manners. So this is a very important and super dangerous phenomenon of our side, guys, that from the side of political theory to political communication and propaganda to the legal scales of anti-liberal attitude, there is a emerging cooperation inside of this four rights hemisphere. It is a very, very dangerous thing, and we have to deal with this topic as well. The other thing here, as I mentioned before, we have to learn a lesson from the interwar period, and I'm trying to do my best to combine the several agendas of the interwar period in conjunction with the anti-liberal attitude. But there are other approaches here which should be important. Take a look at the concept of militant democracy, because it should be at national level and of course at international level, or maybe at the level of the European Union. How can we deal with the far-right phenomena? How can we deal the emerging autocracies in conjunction with the concept of militant democracy? Of course, there are several dangers here. It is obvious that the concept of Karl Loewenstein is very dangerous, but we have to face that at a certain point, For instance, in Germany, it has also happened. It happened in Poland. It also happened in Romania that the political elite or some parts of the political elite is trying to apply this concept in the practice. But it would be very important how to reinvent the concepts of militant democracy in conjunction with our zeitgeist, because it is also very dangerous that inside of liberal democracy, these political and social forces are emerging. Take a look at the Trumpism that the United States proved to be so weak, and the Democratic Party proved to be so weak, and the GOP also proved to be so weak to counterbalance this emerging phenomena of autocracy. So there are several concepts in terms of the political history, and I am pretty sure we have to re-investigate these concepts and practices. Thank you.
Hey. Exactly. Thank you so much. And thank you all for coming and for being with us this afternoon. And thank you to our speakers. Hocam, thank you very much for coming here. And thank you so much, Professor Göztepe and Professor Antal. It would have been wonderful to physically have you here with us. Oh, I love it. But, I hope next time maybe you'll be able to make it. So thank you so much for all your input. So I hope we can continue the conversation forward. Thank you.